Hello, hello, hello. Am I audible? Am I audible? Yes. Okay. Hello, hello. Yes. A very good afternoon, guys. Good afternoon, everyone. Good afternoon, public. Good afternoon. Hi, everyone. I am CS Kajalhante, and today we will be covering company law. Yes, so today and tomorrow, if time permits, in today's session itself, we will be finishing company law. Yes, guys. Okay. So we're already done with ethics. We are already done with labor laws, and now the next part that we are doing today is company law. Now, once company law is done, our entire only commercial laws will be remaining. Majority of the important part we'll get done with. Just 1 second, guys. Hello. हाँ. नंतर call करा please. Thank you. Oh, okay. So yes, as I was saying, we are already in a position where we can say, if we are done with company law today, we will be able to say that yes, we have finished quite a bit of law. Okay, because before this, as I said, we finished with labor law, we finished with ethics, and now if company law is over, we'll be done with major part of law revision. Right, writing practice we are already done. Then revision major part will be done. Only commercial laws will be remaining, and 2 labor laws which I will compile with commercial laws, and will be done. Yes, everyone. Okay, chalo. So without wasting any further time, without wasting any much time, let's move on. So once again, wish you all a very good afternoon. Let's go ahead. Okay. Now, we will try finishing this today itself. Okay. Hi Aditya. Good afternoon. You guys have another lecture going on right now, is it? It seems like you guys have another lecture going on. Yes? Okay. Anyways, no issues. Chalo. So let's start. हाँ ma'am. Okay. Okay, Aditya. So glad at least you came to say hi. Hi. Okay. Yes, let's start. Now, company types and related procedure. Okay, so if we talk about Companies Act, it is like an association of persons. Here, separate legal entity, artificial legal person, etc., etc., n number of features that we will see ahead. But now, what is a company, guys? A company is a contract or any other previous law. Okay, section 2 says that. Now, come on, we all know what company is. You guys have CMA inter exams in like what, a month's time now, right? So obviously, I'm sure you guys know what company means. In foundation also, you guys have at least certain topics related to companies. I'm sure you guys must have discussed at least, okay? And in CMA inter, of course, you've done entire company law. So we all know what a company is. It's a separate legal entity. Like the company and the owner, it's two different people, okay? If we talk about the company, it is an artificial person, but the owner is a natural person. So these are two different people. If we talk about Reliance and Mukesh Ambani, so if there is any case, if we want to get that on Reliance, we won't put a litigation on name of Mukesh Ambani, right? Separate legal entity. Liability is limited. if Reliance goes into loss, we will not capture the assets of Mukesh Ambani. Perpetual succession, perpetual succession. Now, Dhirubhai Ambani formed Reliance, right? So he went, Mukesh Ambani is here, God give him 100 years of age, but then he will go someday, his son will go, his son will go, but Reliance will go on and on and on and on. So, perpetual succession, company goes on forever. Can company buy property in its own name? Absolutely. Separate property. Common sale is like the thappa we call in Hindi, common sale. Okay, it's like a stamp. So again, it's not mandatory. Before few years it was mandatory, but now it's optional if you want to use the common sale whenever you're making a contract or anything. Okay. Now, if we talk about Companies Act, it required common seal to be affixed on certain documents. Okay. Now, if we talk about transferability of shares, if you talk about a public company, the shares can be easily transferred. If you talk about a private company, the shares will not be easily transferred. They're restricted because private people, they're like 200, maximum limit is 200 of a private company, right? So just shares will be transferred among those 200 people. Public company like Reliance Industries, you can transfer your share to anyone, anywhere. Capacity to be sued. Can we do a case against a company? Yes. Can the company do a case against us? Yes. Now, what does corporate veil get? Corporate veil is the protection that the Companies Act gives, that the company and the owner, these are two different people, separate legal entity. But if you are misusing this, if you do this in case of a fraud, you're misusing it. You are not like, for example, if the separate legal entity is given, if the limited liability is given, but as a director, in the capacity of director, you are doing a fraud. Okay, like for example, you are doing a fraud and then you say no, the company did it, the company is different and I am different. There is a protection, there is a veil here. Okay, veil is like a curtain. Okay, so there is a protection. So no, Companies Act will lift this protection and it will treat you and the company the same. No limited liability, no separate legal entity. You two will be treated the same. Hi Aro, how are you? Oh, is it you, Aro? I'm so glad you're here. How are you? How are studies? How is studies going? Okay, so oh, I'm so glad, Aro. I'm so glad you're here. Lovely to see you. Lovely. Good. Studies are going good. Studies are going great. Very nice. Very nice. You're done with your syllabus. Okay. Very good. You're here. We'll just finish revising companies law today and tomorrow. Yes. Not even tomorrow. I think we'll be done with the session today itself. So we'll finish the revision of company law. Hi Aditya, you're still here. I'm glad you're still here. Cute, yeah, you people are. Okay. Now, lifting of corporate veil. Now, when we talk about a corporate veil, this is the protection that the Companies Act gives a particular company. Like the company is different and we as individuals are different. Our liability is limited. Our personal assets will not be attacked, right? But in case of you do a fraud, the corporate veil will be lifted. You're doing dishonest purposes, the corporate veil will be lifted and this advantage will be gone. For example, number one, protection of revenue. So for example, there is one company, main company, ABC. Okay, this is revision. That's why I'm doing this in the most shortest form possible. Okay, I'm assuming that you guys have already learned things. So it's company ABC. It has made 3 subsidiaries, XYZ. Okay, and company ABC, whatever profits they've earned, now they will have to pay tax on it. That's why, for example, let's consider they've earned 30 rupees. So 10, 10, 10. 10, 10, 10. They distributed this 10, 10, 10. Okay, why? So that now they won't have to pay tax and they gave this as loan maybe or whatever. And these companies were formed just for the protection of revenue, tax evasion, no other purpose. Then veil will be lifted and personal liability will be attracted. Enemy character, a company cannot be enemy or friend, but during war, it becomes necessary to lift the wheel and see that who is actually behind the head, who is the head behind this company. Okay, so if for example, if we are at a war with Pakistan, and behind the company, the directors, all of them, the ownership, the promoters, everybody belongs to Pakistan, it will be an enemy company. Okay, prevention of fraud, where we are seeing that directors, if you're the director and you're doing this purposely, you're doing this in a fraudulent manner, okay, just to create you're misusing the provisions to get frauds done and to get your work done, then the wheel will be lifted and you will be held personally liable. Hi Shagun, how are you, Shagun? Oh god, I'm so glad you guys are here. Hi Shagun, how are you? How are studies going? Studies going great. Are you guys missing the law sessions? The early morning law sessions? Okay. Now, if we talk about lifting of corporate wheel for public policy, if you're doing any transaction that is against public policy, even in such case, the wheel will be lifted. Okay, if you're making the company just for sake, just like a show off, a mere sham, as such, there is no major role. It's just for sake. Again, in such a case, wheel will be lifted. Where a company acts as an agent of its shareholders. Okay. So, if for example there is an arrangement between the shareholders and company, that company will act just as an agent. Okay. So the shareholders will have unlimited liabilities, because here an agent is always represents a principal, right? So if you're acting just as an agent, your liability will be personal then. I miss you, ma'am. I miss you too, guys. I miss you too. No, I'm glad. Chalo, let's study company law today. Okay? Let's revise. You'll give me answers. Okay? I hope that you guys have studied company law. I have only taught you all company law. You all better give correct answers. Don't knock it off, Miri. Okay? So let's revise company law today. Okay? So, yes. Aditya? Oh, okay. Okay, next. Avoidance of welfare legislation. Okay, wherever company tries to avoid its legal obligation, like for example, PF. I'm sure you guys have done labor laws. Yes, Shagun, Aditya, you guys have done labor laws, correct? So, where's Aro? Aro is gone or what? Yes, so in labor laws, you must have seen gratuity, PF, minimum number of employees, this and that. Okay, so this amount has to be depending upon the number of employees, the provisions will be applicable to you, right? So you just make new companies and you show their employees on their other payroll so that you can avoid welfare legislation like bonus and stuff like that. Then it's very wrong. Okay, limited liability wheel will be lifted. To punish for contempt of court, company being an artificial cannot disobey the orders of court. It cannot disobey the orders of court. Okay, so if it does, wheel will be lifted. Okay, now listen. This was the basic. I'm picking up speed. Okay. Shagun, ask our gang to come online. All of us. All of them. So, we'll revise company law like this today. We'll do the entire company law. I came very josh mein now. Okay. Kinds of company. Companies can be formed for lawful purposes. Okay, so if it's a public company. Hi Simran. Hi Simran. Good afternoon. How are you, Simran? Yes. So if it's a public company, guys, we need 7 or more people. If it's a private company, 2 or more people. OPC 1. Okay, I'm going to increase the speed now. And we are going to finish company law before 6 o'clock. Done, done. Yes. Now, companies may be limited by shares, limited by guarantee, unlimited. Now, what do you mean by limited by shares? Limited by shares means a company whose liability is only limited up to the unpaid amount of share capital. Guarantee means, do you give the money right now? No. When do you give the money? At the time of winding up. So, and you promise that I will give this so and so amount. Okay. And unlimited means it's an unlimited liability. Your personal assets will be attached. Yes. Now, what is the further classification? Statutory company, registered, existing, not-for-profit, government, foreign, holding subsidiary companies. Okay. Yes, all of them are there ahead in detail. So we'll do it in details there. Private company, guys. As you guys know, private company, can you transfer the shares easily? No, it's a private company. What is the maximum number of people? 200. Minimum 2, maximum 200. Can public come and get the securities? No, because it's not for the public. No, it's for the private people. Yes. Then, Companies Act remove the minimum paid up share capital requirement just for the company registration simplification procedure. What happened before a few years, there used to be a minimum paid up capital requirement. Okay, but right now that is removed, that is gone. Okay. Only there is a restriction on transfer of shares. Okay, shares cannot be transferred. And when you count this 200 member limit, okay, now I'm asking you a question. Please tell me, everyone, fast. When you are counting this in a private company, maximum 200 members are there. So when you're counting this 200 member, do you include the employees in it? Yes or no? Fast. Do you include the employees in it? Existing employees. Fast. Tell me. Then, for example, there was an employee on 1st of November. He resigned on 3rd of November. And he bought shares. He bought shares on 5th of November. Case number 1. Okay. Case number 2. He was an employee on 1st of November. He resigned on 10th of November. He bought the shares on 3rd of November. In which case? Can you see it, guys? Should I change the color? Yeah, I think I should. Okay, so listen, when in the first case he has resigned on 3rd November, okay, and he bought shares on 5th November. Got it? He resigned on 3rd and he bought the shares later on. So when he bought the shares, was he an employee? No. So will he be counted in the 200 when you're counting the 200 member limit? Yes. Okay. But here, 1st of November, he was an employee. And 3rd November, he bought the shares. So here, when he bought the shares, was he an employee? Yes, because he resigned on 10th. So even after resignation, he's still a shareholder. But when he bought the shares, he bought it as an employee, right? In the capacity of an employee, he was still the employee of the company. So in such a case, he will not be counted in the 200 number. Yes. Guys, remember, guys, getting it? Are you all there? Are you all with me? Are you all getting it? Yes. Okay, ma'am, clear. Very good, Aditya. Okay, now public company. Public company is one that is not a private company. Okay? Wow, breaking news, like we didn't know that. Now, public company, how many members? At least 7. Maximum, no limit. Right? Unlimited. Okay, whereas private is 2 to 200, public is 7 to no limit. Okay, now public company, remember for private company, minimum number of directors is 2. For public company, minimum number of directors is 3. Don't get confused in this. For public company, minimum directors is 3, but minimum members is 7. And for private is 2. Okay? OPC. OPC, the name itself says it, one person company. So one person company, only one person will be the member. Okay. That may be limited by shares or limited by guarantee. The memorandum must include the name of another person with written consent who will become the nominee. Okay. So OPC is this like one person. So if this one person goes off, then his nominee will come into the picture. his nominee will come into the picture. If this one person is handling the company, no, he's dead now, or he becomes insolvent, then the nominee will take over. So the nominee's consent has to be given beforehand only. OPC single member, all his rights will be transferred to nominee once he's dead. There are fewer filings, no AGM required, and all of that. It's a company, but one person, so that's why formalities are very less, and it can be registered anyhow. Now, what are this is important, relaxations available to OPCs, exam POV many times asked. This question is asked many times. N number of times, many times this question is asked, okay? So no CFS is required, no cash flow statement. Annual return can be signed by the director if there's no company secretary. Generally, a CS has to do it, right? But here it can be signed by the director. No AGM or EGM is required at all, otherwise AGM is compulsory. Then board or member resolution can be recorded in the minutes book. Financial statement can be filed within 6 months. Okay. Okay. Now, eligibility. Only a natural person who's an Indian citizen and resident in India. Resident in India means he's been in India for at least 182 days. This is the criteria for residency. Okay. He can incorporate an OPC and he can act as a nominee for an OPC. Okay. Now, if a person who's an NRI, can he act as a member of OPC? No. A person who is an NRI, can he become the nominee? No. So, if you want to become the nominee or that OPC incorporation, one person, okay, so you need to be a natural person, only Indian citizen and resident in India, 182 days, okay. One person can incorporate only one OPC. Can minor become a member or nominee? No, because he is not a comparison to a party, right? OPC can never be a Section 8. OPC, can it be converted into other type of company? Yes, but only after 2 years. But what if it wants to convert it before 2 years? What if it's become that big? Fine. If your paid up share capital has become more than 50 lakhs and if your turnover has become more than 2 CR, you automatically get converted from OPC into other format of a company type. Okay. Ma'am, if there's only one person in an OPC, how is it's still a separate legal entity? Very good question, Aditya. Only one person is there in an OPC. Even nominee, as I said, once the owner is gone, like once the main person is gone, then the nominee comes into the picture. Till then, even the nominee is not there. But when you don't want to do a sole proprietorship, in sole proprietorship, liability is unlimited. When you don't want to do that, and you're ready to do certain formalities and you're doing a business in a very formalized way. That's why companies that gave you an option, fine. If you don't want to do a sole proprietorship, go for an OPC form. Just because you don't have a partner doesn't mean you can't do business. Okay, that you will have to have one more person so that at least a private company can be formed. No, you want to do it alone with the advantage of limited liability. Purposely they've given this so only one person can do it. Okay. So yes, generally if OPC becomes that big that it increases its turnover of more than 2 CR or PUC of more than 50 lakhs, it can get converted into any other form. Otherwise, the conversion is allowed only after 2 years. Yes. Now, what are the benefits of OPC? Limited liability. Liability is extremely limited because obviously it depends on the contribution. The liability here, it will not go on his assets. Personal assets, correct? Legally, it's recognized by law. OPC can go to the bank and they'll give the money more easily, right? Entrepreneurship, people will do business more and more. Simple compliance, it's not as complicated as a public or a private company, and offers direct market access without middlemen. Now, nominee. As we said, nominee and his name and consent form INC 3. Okay, it must be filed during incorporation. I remember we used to take the lectures, I used to ask you to guess the form names and then you guys used to most of the times guess it wrong. Okay, so when you're doing the incorporation at that time only you give the nominee's name in INC 3. Can nominee take back the consent? Yeah, he's not interested to be the nominee anymore. So can he take back the consent? Absolutely. Okay. Any change in nominee? Fine. There is a change, no problem. Just inform it to the registrar within 30 days. And once a member is dead or incapacitated, nominee becomes a member and must appoint a new nominee. Okay. So now the person is dead. Now this nominee has become that main person. Okay. So now he will have to appoint another nominee, right? And what if the nominee only gets dead before the main guy? It's okay. Then the main guy will appoint somebody else as a nominee and inform ROC within 30 days. Simple. Okay. The contravention of OPC provisions attracts fines up to 5K and 500 per day. Now, share certificate in OPC, it must be issued under the company seal. It must be signed by one director and CS. Now, management and administration. Now, if we talk about the resolutions that are passed by a solo member and recorded in the minutes book, it's deemed to be valid. Okay. It's an OPC, no guys. So, OPC, it is going to be passed by one member. It is a valid one. And resolutions that are signed also by only one director. Is it valid? Yeah, because Aditya, as you said, just is one person, no? Annual return, it must be signed by CS. If there is no CS, then a director. OPC does not have to get into the postal ballot provisions at all. It has many relaxations, no? Can we convert OPC into public or private? Yes, but only after 2 years. But what if we want to do it before 2 years? Increase your PUC of 50 lakhs and turnover of 2 CR. Then public company you'll have to have minimum 7, then private minimum 2. So you'll have to increase the number of members also if you want to convert the company type, correct? Done. Okay. Okay. Application to registrar in form INC 6. A private company who wants to convert into OPC. Can a private company be converted into OPC? Absolutely no problem. They just need to bring down their PUC and turnover then. It should be less than 50 lakhs, turnover should be less than 2 CR. File form number INC 6. Take an NOC, the members have no problem, the creditors have no problem. Take a director's affidavit, the directors are okay with it. List of members, creditors, creditors are absolutely okay with it, and the financial statement. File all this with ROC, and on approval, you will get a conversion certificate. Yes. Okay. Now we'll talk about a small company. A small company meets both the conditions, where PUC is grade C. A small company is a company, remember this, 10 times. Okay, how do you calculate it? 10 times. PUC and turnover. 2 CR, turnover 20 CR. So if PUC is up to the limit of 2 CR, if turnover is up to the limit of 20 CR, okay, it is a small company. Okay. It files annual returns in MGT 7A within 60 days of AGM. Okay. Generally, we file the annual return in which form? Generally, companies do it in MGT 7. For small companies, we do it in MGT 7A to make it very easy. And we have 60 days even after AGM. Okay, got it? So, small company, once again, PUC up to the extent of 2 CR, turnover up to the extent of 20 CR. Okay. Registered company, that one that is registered under Companies Act, it has limited liability. Certain companies are registered as unlimited liability companies. It may be private, public. LLP. Now, what is an LLP? Guys, come on, yeah. This is so basic. What is an LLP? If you talk about section 3 of Companies Act, what do LLP do? So now, you want to do a business, like you want to establish a company, but you are confused if I should go for a company or if I should go for a partnership. If I go for a partnership firm, liability will become unlimited, and I don't want that. But if I go for a company, liability will be limited. But I don't want so many formalities also. So what do we do? Scooby-Doo, LLP. That's what we form. Okay, we form an LLP. Here, in case of LLP, liability of the members is limited. Got it? On the amount of unpaid amount of the share capital. The liability is limited. So it's like a mixture between partnership and company. Here you will get a partnership format like flexibility, but it is going to be a company. So liability will be limited. And when liability is limited, the legal entity is separate. Clear? Now, liability, it can be enforced during company's existence and winding up. Share capital determines the extent of liability, as I told you. Okay. If it's by guarantee, then at the time of winding up, whatever amount the shareholders are going to give, that is a liability. Unlimited liability, we all know there is no liability then. Your personal assets can also be at stake. Now, associations for not-for-profit. Section 8. Guys, Section 8 are those companies that are made with a POV of doing charity, that are made with a POV of social and educational objectives. Okay. So, profits must be applied to company objectives, no dividend to members. So, now Section 8 company. Ma'am, Section 8 company is done for charity. Yes. Example of Section 8 company, schools, colleges. Okay. Educational purpose, cultural purpose. These are the examples of Section 8. Okay, ma'am. Got it. So, what if Section 8 can never earn profits? Of course, it can, Baba. Of course. Okay. Section 8 can get Section 8 can earn profits, but it cannot distribute its profits amongst the shareholders. Okay, it can use its profits for its own members itself. Okay. Limited company privileges apply here. Central government approval, licensing is required if you want to register yourself as Section 8 because you will get so many taxation benefits. Yes, license can be revoked if company acts in a fraudulent way. Now, exemptions. Appointment of CS is optional completely. AGM notice reduced to 14 days. Generally, if we want to give an AGM notice, it's 21 days, right? But here, Section 8 for them, 14 days is also fine. 14 days before you give the notice. There is no strict provisions as to number of directors and all. We have to apply for a form in INC 12. A memorandum goes in INC 13. Declaration goes in INC 14. And income and expenditure estimates. Okay, we apply to ROC with all these documents. Then registrar will see that is there anyone else, a third party, who has objections toward this. And if not, they will issue a license in INC 16 or 17. Yes, clear everyone? Guys, clear? Yes? Okay. Now, easy? Not going too fast? Yes? I'm a party exchange in LLP. Like a separate legal entity? Of course. Of course. It will be a separate legal entity. Even then. Okay, revocation of and winding up. License. Guys, you're taking a Section 8 license that I'm going to do charity, I'm not going to earn profit. Even if I earn profit, I'll give it to my members. Okay, so don't ask me to any pay tax. You're registering yourself as a Section 8. Fine, great. But then whatever you had promised, you're not doing that. Okay, so in such a case, company will violate, like companies violating rules. So here the license can be revoked by CG. Okay, and remaining assets on winding up, it will be transferred to the insolvency fund. Now, can a Section 8 convert itself into other type of company? Of course, but subject to certain conditions. What are the conditions? What kind of a resolution you need? Number one, SR. You give them reasons, date, objects. That why are you converting yourself into a company now? You are a Section 8. Why are you converting yourself into a public company now? Reason. And what effect is it going to have on your members? That is also required. No, it's important. Then show me your resolution and then file MGT 14 with ROC. You have to give a newspaper and you have to give a notice in the newspaper also now, because people around you, how will they know that you've converted the company? Yes. And serve notice to authorities like Chief Commissioner, Income Tax Commissioner, Chief Secretary, because all of them should be aware. Right? All of them should be aware. All of them should know that now you are no more a Section 8. And now you're a company, which is maybe you're a public company, and now you're going and doing business there. You're earning. Have you ever heard of a school called Vincent's Private Limited? No. Because have you ever heard of a hospital saying Ruby Hall Limited? No, because these are Section 8, and Section 8, they do not need to use the words private limited or limited after their names. Got it? Now, order for conversion, guys, RD, he approves the conversion order. He says that now you will have to give up the benefits. Now you will have to start using private limited or limited. Now you will have to pay tax. Okay? First you settle all the dues of creditors and then you get converted. and then transfer the remaining balance to IEPF. Okay. Now, filing with registrar. You pass a special resolution, and also now you'll have to amend no the MOA AOA, because the MOA AOA are made as per section 8. Now you're converting it. Okay. RD approves it in which form? INC 20. RD approved it. Now alter MOA AOA. Done. Now whatever the conditions are, please comply with that. Done. Then ROC will give you a fresh COI where you will be known by a new company. No more section 8. Clear? Yes. Okay. Can we move on? Guys, any doubts? Please let me know. Anybody, any doubts? Yes. Any doubts, public? No? Okay, I'm moving ahead. Now we will talk about a government company. Now, what is a government company? Guys, government company is a company. Government company is a company where at least 51% of the capital is held by CG plus SG, or by both of them. Like for example, CG holds half of it, SG holds half of it. Like CG has 30%, SG has 26%, that's 56%. So it will become a government company. Or it is held by any company which is a subsidiary of a government company. Okay, so for example, a government company. A government company is controlling another company. So that another company will also become a government company. Yes? Okay. Now, government companies are incorporated under Companies Act. They always have a separate legal entity, or just like any other company. Okay, their employees are not any government employees. It's a normal company. Now, there are so many government companies, guys, where CMAs have such great scope, such great exposure, such great scope in so many government companies. That doesn't mean their employees become government employees and they're going to get pension and this and that. No, of course not. Okay. Now, okay, done. Foreign company. The name itself suggests, guys, what is a foreign company? Foreign company is incorporated outside India, but it has place of business in India. Okay, either physically or through an agent or electronic, or it conducts business in India in any manner. Okay, now company is incorporated outside India, but it has business in India. Got it? It can be even an online business. It's not necessary that they have to have a physical place. Even if it's an online business, it will still be considered as a foreign company. Okay. Now, what if there is an Indian company and the shareholders are foreign? Does this become a foreign company? Nope. Nope. Okay. Now. Okay. Done. Holding and subsidiary. Now, if we talk about holding and subsidiary company, these are relative terms. Holding company controls another company. Okay, whenever we talk about these two companies, we connect both of them and talk. Okay, so if we talk about holding company controls a subsidiary company. Got it? So, holding company is a company which one or more other companies are subsidiaries, and subsidiary company. Now, for example, how control? See, it's a holding company if ABC company, XYZ Limited, ABC Limited, subsidiary. So here holding company subsidiary ABC Limited holds 56% of XYZ. Will it become a holding company? Absolutely. Absolutely. Will it become a holding company? Clearly. ABC Limited is giving 56% to XYZ Limited, holding subsidiary. Because the entire control, all the decisions will be taken by ABC, no? Number one. Number two, it's an ABC Limited, XYZ Limited, okay? It holds 13% share capital. Is it holding subsidiary? No. But all the directors of XYZ are accustomed to act as per the instructions of the directors of ABC Limited. Got it? Now is it subsidiary? Yes. Clear? Again holding subsidiary. Though the share capital is less, the shareholding is less, but still it is holding subsidiary? Yes. Okay. Now, there is a holding company, its subsidiary, and this company is subsidiary. So, will this become an indirect subsidiary? Yes. Okay, so now if the board controls the appointment, the removal of majority of the board of directors of other company, holding subsidiary, I already explained it to you. Okay, now associate company. What is an associate company? Again, associate company means it does not have half of the control, like 50% control, but it has a significant influence on the other company. Okay, now what do you mean significant influence? At least 20%. So 20 to 50% shareholding if you have, those two companies are known as associates. If you have more than 50%, then you will be holding subsidiary. Yes, okay, good. Then, what is a public financial institution? PFI. Guys, getting it? Is it too fast or it's fine? Absolutely okay. Ma'am, we are managing, ma'am. We have exams in few days. The speed is absolutely fine. We've only been studying. We haven't been doing anything else. Is it right? Yes, is it right? You guys have only been studying and doing anything else. I hope that's the case, because that should be the case right now. Okay, your focus should be completely on studies. Okay, chalo. Now, public financial institution. So, public financial institution, for example, LIC, Infrastructure Development Finance Company. Okay, any specified company referred in the UTI. Institutions notified by CG. Okay, so what is exactly PFI? Public Financial Institution. Okay, public financial institution, first of all, an act, okay, let it be of the central or the state, an act needs to be there. Only then an institution can be declared as a PFI. Public financial, so it relates to money, but it's public financial, means who will hold the shareholding? Government. So central government or CG or SG plus both of them in combination, at least 51%. Okay, these institutions are for the benefit of the public. In case of financially, like if you talk about LIC, I am sure you guys know what LIC is, life insurance company, right? So these provide insurances to public. Public can go and invest their money there. Okay, so here the ownership, half of the ownership, whom does it belong to? The government. Clear? Yes, everyone. Yes, everyone. Okay, now we will talk about producer companies. So, what is the concept of producer companies? In India, it was introduced to allow cooperators to function as a corporate entity under MCA. Okay, so what are producer companies, guys? Trust me, if I'll give you a trick to remember producer company. Any company which is included or which is into an agri kind of a business that is related to agri, that is nothing but a producer company. Okay, so for example, procurement. If you're involved in procurement, if you're involved in harvesting, pooling, marketing, selling the agricultural stuff, production of agri, grading of the food products, handling of the raw materials, agriculture related products, exporting of all this, then in all such cases you are a producer company. Okay, so it's like you need to what happens, even agriculturists, even farmers, whatever they are doing is also business. So you need to recognize them officially and formally. So how do you do that? By giving them the tag of being a producer company. Has it to be registered under Companies Act? Absolutely. Who can form a producer company? You need at least 10 individuals, okay, or 2 institutions, or maybe a combination of both. Then you can form a producer company. How many number of people you need? 10 individuals or 2 institutions. Yes. Now objectives we already saw. Now how do you form a producer company? A company may be formed by any lawful purpose. Any lawful purpose, okay? It requires minimum how many people? 7. Private company, 2. OPC, 1. Can you form a company to kidnap people? No, it's an unlawful purpose. Okay. Okay, next, registration process. If we talk about registration process, the registrar registers the company based on the documents. It issues them a COI. Then a SIN is issued. What is a SIN? Corporate identity number means the way we have an Aadhaar number. All of us have separate Aadhaar numbers, separate PAN numbers. Everybody's identity is unique. So similarly, CIN, corporate identification number, is a unique identity of all the corporates. Okay. If you do anything wrong, if you tell the ROC any lie, if you're portraying any lies about your company, Section 447 will be attracted. Now, what is Section 447? Guys, it's considered as it's considered as a Dracula section. Dracula section. Section 447. Okay, everybody is very scared of such a section because the liability is major and it directly comes on the person. Okay, all professionals are scared of this section. Now, if we talk about promoters, they must select a name. Okay, the names that are undesirable, that cannot be adopted. Now, you cannot put a name of your company as Pakistan Zindabad Limited. This is undesirable. Okay, you need to reserve your name first and then you go ahead with the registration process, right? First, reservation of name, INC 1. Then notice must be filed for articles in INC 2 or INC 7 at incorporation or form MGT 14 for existing company within 30 days. This is for entrenchment. Now, incorporation of company, guys, it's simple. Promoter, he must submit these documents to the ROC, then your company can be registered. But before this, have you already reserved the name? Yes. So you submit the MOA. Okay, you submit a declaration by professional. Okay, what declaration? What, ma'am? What do you write in that paper? You write that the directors have not done any fraud in the last 5 years. Okay, and the documents that have been submitted are true to our knowledge. The documents are also not false. Okay. Then correspondence address, you need to give your registered office address. You need to give the details of the subscriber. When I was teaching this, like teaching, right now we're doing revision, right? But when I was teaching this, I had shown the subscribers page, I remember. So that page also needs to be given where all the details of the subscribers, their names, their address, their signature, everything is given. And consent that the subscribers are the first directors of the company as good as. Okay. Now, company cannot start business until the first directors have filed a declaration. No. Within 180 days, they need to file a declaration. Okay. What declaration? That all of us have paid the amount on the shares and the registered office is verified. Because if directors only have not paid, how will you expect the other people to pay? Right? Directors as in the subscribers. So here the subscribers is to say that within 180 days, we have paid the entire amount to the company, Baba. And we have also verified the registered office, all good from our end. Right? It's like a traffic police guy. There are 3 traffic police officers and they're going triple seat and they're telling someone else that you are not wearing a helmet. Will you listen to such police officers? Of course not. So we expect that first you yourself follow the rule. You're the subscriber, follow the rule and then ask others. Yes, okay. Now, Shagun, where are you guys? You're done for the day? Your lectures are over? Ma'am, are you going to take separate session for writing practice and company law? Adi, I have already taken a writing practice sessions of all the law topics, all of them. Yes. Clear. No lecture. You guys are done with the syllabus? Okay. Now, let's move ahead. Memorandum. What is an MOA? Now, guys, remember MOA. Come on, we are almost getting done with the important part now. Okay? Till 6, I told you maximum till 6, you guys will be done with this. Okay? Now, what is an MOA, guys? MOA, it is a charter document of the company, the most important document. What all does it have? It has a name clause, number 1. If it's a private company, it will end with private limited, public company, public limited. Okay. Then it has a registered office clause, where your registered office is situated. Entire registered office address is given, no, only the state in which your office is there. Object clause, what is the purpose? Why have you been formed? What is your object? You formed a company, no, why? What do you want to do? Okay, liability clause, if it's emitted by shares, unpaid amount of share capital, limited by guarantee, then at the time of winding up, you have to pay. But MOME, you have to write this, that you are that exactly what is the liability of the members. Capital clause, how much capital have you given the company? What is the divisions? Okay. And if it's an OPC, you have to also give details about the nominee, right? Because if this one person dies, the company is gone, the company is dead. Okay, so now MOA, Schedule 1. What is the doctrine of ultra vires? Doctrine of ultra vires means there are certain objects, okay, this object clause. There are certain objects that only this you're supposed to do. When you've incorporated a company, there are only certain objects that you are allowed to do. But if you exceed your authority beyond this, you are not authorized to do this. I remember when I was telling this, I was teaching this in details. I given an example of the younger brother going for a party and things like that, right? So you are not authorized to do that act, and you did that act. That is an ultra vires act. Okay, you are acting beyond the powers that are stated in MOA. MOA gives you the powers, MOA gives you the authorities, and you are acting beyond that. You're acting beyond your authority. Invalid. Okay, so neither the company nor third parties can enforce this. Okay. Okay, now any acts beyond directors' powers can sometimes be ratified by shareholders. If the directors did not have it in power, then the shareholders can ratify because it's still in the MOA limit. But if the MOA only did not approve that, then this is an ultra vires act, and you cannot, even if all the shareholders come together and say we want to ratify this act, no, you cannot. Okay, now AOA. Now, if we talk about AOA, it sets the internal management rules. Okay, AOA talks about the rules and regulations like share capital, well, when will you do the next calls, the rules regarding transfer, transmission, buyback, then how will the general meetings be held, what will be the rules regarding the proxies, how many board meetings will be held, then the rules regarding the CEO, the manager, dividends, winding up, accounts, all these, the basic rules regarding all this. Okay. Now, MOA and AOA, subscribers should compulsory sign it. Okay, if they are illiterate, thumb impression. But nowadays, I think everybody knows how to sign. Then registration and obligation. ROC registers the documents and it will issue a COI. We've already done this. After issuing a COI, the company will get CIN. We've already covered this. Okay. Now, if we talk about false information or suppression, 447 section will be attracted. Simple. I told you this is a Dracula session. This is the worst section. Okay. So the tribunal may regulate the company management. The tribunal will see now. Okay, you did a fraud. You know what? I will amend your memorandum. You know what? I will run your company now. Okay. Or I am removing your company. I'm winding up your company. Can the tribunal go to this extreme? Absolutely. The tribunal can wind up directly. It can give the winding up orders. Yes, alteration of MOA and AOA. Section 13 allows alteration of MOA via special resolution. For example, name change. Can you change the name of the company? Absolutely, no problem. Okay. Can you change the registered office? Absolutely, no problem. Can you change the objects? Absolutely, no problem. Just give an SR, special resolution. Alterations must be registered. Okay. Now, can AOA be altered by SR? Absolutely, no problem. Can it be converted from private to public? No problem. Okay. Tribunal, if tribunal approves it, INC 27, let the conversion be done. Okay. Then companies must provide copies of MOA, AOA, all the resolutions, everything within 7 days. If you've converted yourself, no, within 7 days, provide all the agreements, provide all the resolutions, everything. Okay. Now, a company name. When will the central government, can you change the company name on your own if you want to? Absolutely. Can the central government change the name of the company if it wants to? Yes. When will they give such an order? If your company name already resembles an existing company name, number one. Okay. If, for example, if we register for a company called as Reliable, it's very much similar, no? Resembles to Reliance, Reliable. Okay. Then, or it resembles a registered trademark. So, for example, we say we want to register a company of this spelling, Reliance. No, you can't, because it already represents a registered trademark. Like, for example, a very famous thing that happens in India, Puma becomes Poma. Yes? Okay. Now, subsidiary company and holding company, I've already explained this to you. Okay, documents, how can they be sent? They can be sent via electronic means or even courier, post. KMPs will authenticate this. Now, who are KMPs? I will be telling this to you at the end of this chapter. Okay, now, registered office of the company. What does section 12 say? Every company, it must have a registered office. Every company, okay. Now, if we talk about company having a registered office, why? Because all the communications will be sent there. And the registered office, it must be opened within 30 days. You got incorporated today, within 30 days, open your registered office. Verification of registered office, you must furnish the verification of registered office to ROC within 30 days of incorporation. How do you do this? INC 22. You submit INC 22. INC 22 talks about the registered office. Okay. Now, when you're giving INC 22, you're giving details of your registered office. What all details do you give? Registered document showing title of premises that you show. Okay, no, I am only the owner. Trust me, I am the owner. Okay. Notarized copy. Authorization from the owner. If I'm not the owner of this premises and this is my registered office, so I need to show that, okay, I'm not the owner, but Mr. X was the owner and I have taken this on rent from him. So rent agreement dikha do. Give away the rent agreement. Okay. Okay, and then you give a proof of any bill, like a light bill, like gas bill. So it shows like who's the original owner. Right? Yes. Okay, now next. Even this part, if we get done, it's enough, like it's a good enough part. Okay. Now next is publication of company name. Every company publishes its name in multiple ways. How do you publish your company's name? Guys, the first thing that we do is we can affix the company name and the registered office address. anywhere, wherever we want, at the entrance of our office, at wherever we do business, at all such places, at least one language must be the local language of that place. Okay, so if you're doing it in Maharashtra, so it should be written in English if you want, and in Marathi. Okay, if a company has a seal, the name should be engraved on it. Company name, registered office address, your SIN, telephone, email, all this, every time, whenever you're doing any sort of communication, let it be notice, let it be you're giving out a circular, any sort of notification, no, any sort of communication. Make sure in such notifications or in such communications you are including the name of your company, the name of your registered office, etc., etc. Okay, now print the company name on hundis, promissory note, bills of exchange, and OPC must include the words OPC below the name wherever it is printed. Okay, so for example, you give A, B, C, OPC. Got it? So people get to know this is a one-person company. Now, can you change the name? Yes, you can. But for 2 years, with the new name, display the old name also for 2 years. So that till the time people get used to it, public get used to your new name. Gotcha? Yes, everyone. Clear, everyone? Easy, easy, easy. Now we will talk about change of registered office. So, requires a company notify the ROC within 15 days regarding any change. If you've changed your registered office, INC 22, okay. INC 22, I told you, no? INC 22 is situation clause, means registered office clause. Anything related to registered office, everything you give it in INC 22. Yes, okay. So, the registered office, it can be shifted within the jurisdiction of the same ROC, or it can be shifted from one ROC to another, or you might change the entire state of registered office. If you change the state, you will have to alter MOA, because MOA consists only of the name of the state. In other cases, if you are in the same city, will you have to alter the MOA? No, absolutely not. Clear? Okay. Now you shift the registered office within the same state, file INC 23 with the RD along with the fees. Attach the following: board resolution, special resolution, declaration by KMP or 2 directors that we have paid all the creditors, we have paid all the employees, okay. Then declaration that we will, whatever court cases are going on, it will go on. We are not changing the court jurisdiction. If our court cases are going on in Chennai, it will go on in Chennai only. Okay. Now, RD communicates this confirmation within 30 days. Company files this with ROC within 60 days that we are changing our registered office. Now, ROC says within 30 days, okay, fine. And then the change take place. Okay. Now, when can we not shift? When there is already, please, this is important, MCQ, not MCQ, but theoretical POV, very important. If there is an investigation that is going on in your company, will you be allowed to change the registered office of your company? No, because investigations are going on. Yes. Now, what if we are shifting a registered office from one state to another? From one state to another, you are shifting your registered office. INC 23. Along with that, you give a copy of MOA. Along with that, you give minutes. Along with that, you give a board resolution. Okay, got it. Then you give the list of creditors that you have paid them. It's not like you're running away. Names and addresses and declaration by CS that no employee will be removed just because of this particular reason. Okay. Then keep a copy of the creditor list that any government officer can come and inspect it. Okay. Then you need to publish an advertisement even in vernacular newspaper, English newspaper. You have to, all the creditors individually, you have to give them notice. Okay. Then authenticated copies like advertisement, notices, their authenticated copies must also be attached. Okay. If no objection, application may be approved without hearing within 15 days. Now, if the public takes why do you give a newspaper advertisement? Always. Remember, in company law, everyone, remember, in company law, whenever you are giving an advertisement, you are giving this with the purpose of inviting objections. If you get an objection, fine. If you don't get an objection within 15 days, you will be approved. Yes, but what if you get an objection? Central government, they will call them, it will call you, it will listen to both the parties, it will see who's correct, who's wrong. Okay, and then 60 days it takes for this entire long process. Okay, then. So when CG approves it, in INC 28, inform ROC within how many days? 30 days. Yes, I could just make a chart out of it, but I guess this is like, it's very easy, right? It's like step by step, one by one, very easy. Okay. Okay, now punishment for default. Now next, if we talk about a public offer, what is a public offer? A public company may issue securities. Whenever you're issuing securities, you first issue a prospectus, right? I hope you guys know what prospectus is. What is prospectus? What is prospectus? What is prospectus? What is prospectus? Prospectus, I keep telling you all, I had given you all an example of this whole marriage thing, the shadi part. Remember, I had given that example. Like if you're getting married and then there is a shadi.com profile that you have to make. Okay, now, even private placement can be done, like you are allotting these shares to few people. Okay, and through a rights issue or bonus issue, even that can be done. Now, what is a rights issue? What is a bonus issue? If you talk about rights issue, shares to existing shareholders. And bonus issue means, again, shares to existing shareholders, but for free. Got it? So, a private company will issue securities either by way of rights or bonus or through private placement. Now, public offer, it includes IPO or FPO. IPO means you're doing it for the first ever time. FPO, after that, every time, whenever you're doing it. Okay? Okay. Yes. Clear now. What is a prospectus, guys? What is a prospectus? Every public company, whenever they are issuing a prospectus, you need to give in exact details about your company. Why? Because people are going to see this prospectus and then they are going to invest in your company. Prospectus is details of your company, your directors, your company, the business you do, the history that you have, your past, your future plans, your present, everything. So the prospectus has to be as per SEBI, Companies Act, SICRA, okay? And first, before publishing it, you first give it to ROC and then publish it in public. And it is valid for 90 days. Like for example, you give it to ROC today and then you're giving it to public after 5 months. No. Then fresh prospectus will have to be filed. The day you give it to ROC, you can give it to public within how many days? 90 days. Clear? Okay. Now, variation in terms or objects. Now, if we talk about a company, can you change your object clause? Not at all. You require easily? No. Can you? But of course, yes. But then you have to take special resolution, that too through postal ballot. So even if the member does not come into the meeting, he's sitting at home and he's sending a postal ballot to you or e-voting. So all the members can, like vote. Okay. Okay, done. Now, if you're changing the notice, advertisement of that notice must also be given. In which form? Pass 1. It should be published and even the postal ballot notices should be given. The people who are not okay with this, the new object, the new purpose of your company, you should give them an exit opportunity. Okay, you should tell them what was the original purpose, what is the new purpose, what was the total money that was raised and utilized, how much are the remaining funds, why are you changing the objects now. Okay, justify it. Till when will you achieve the new objects, what are the risks that is relating to the new objects. Okay, so that they can make a proper decision, no, when you give them all the details. Okay, now Demat, guys, all shares must be in demat form only. Now, whenever you are giving out a prospectus, it will include all the details about members, objects, share capital, everything. Okay. Now, what is a shelf prospectus? Shelf prospectus means, guys, every time that you go in the market and you ask for money, you have to keep issuing a prospectus. Instead of that, just issue a shelf prospectus and say, in this entire 1 year, how many ever times I go to the public for money, this will be applicable. This prospectus will be applicable in the entire 1 year. Yes, okay. So it's used for multiple offers over a period of 1 year. Okay, now red herring prospectus, RHP. Now listen, once you've issued a shelf prospectus, do you have to issue prospectus every time you're giving an offer within that 1 year? No, you don't. Okay, now next, RHP, it does not include full details of quantum or price of securities, must be filed 3 days before subscription. It must be filed 3 days before subscription. It does not have full details, guys. Okay. It does not have details about the price of securities, because maybe the securities are going to be priced at there is a process of bidding. Whoever bids the highest gets the security, like the securities will be priced at that amount. Okay, so now after the bidding process, you're going to get the price. Baki, all the details you will give. In what? RHP, red herring prospectus. Clear? Yes. Application form. Now, forms for purchasing securities, an abridged prospectus should be there. What is an abridged prospectus? Abridged means shortened. Short. Okay. Now, every time if you're issuing an abridged prospectus, that's okay, not a problem. But you have to issue about the details about the changes between the original prospectus and the shortcut wala prospectus. Okay. Liability for misstatement. If it's a criminal liability and civil liability. If it's a criminal liability, guys, unless the statements were immaterial or made in good faith. If you've made the statement in good faith, you did not intend. Intention is important. You did not intend to do a fraud with someone. Till that time, fine. It will just be a civil liability. Okay. But if you intended, then it will be a criminal liability. Purposely you did it. Purposely you lied and took the money from the shareholders. Purposely there was a false statement in the prospectus. Then it's wrong. Yes, okay. Now, no liability if the director withdrew the consent before issue. The director did not know this is going to be issued and he withdrew the consent. Expert statements were fair and accurate. And a statement had been given by expert and we believe that. Okay, like a CMA or a CA or a CS, and we believe that. And prospectus, if it was, we are the director and we did not know and it is issued without our knowledge, even in such a situation, no liability. Got it, everyone? Yes. Okay. Fraud remedies. Allotment of securities. Okay, now, very easy part. Allotment of securities. Okay. Shagun, are you there, Shagun? Aditya, are you there? Hi, Simon. How are you? Aditya, you're there? Hi. Very good, yeah, Aditya. Very consistent. Appreciated. Very consistent. Okay. Oh, Shagun. Hi, Shagun. Shagun, Aditya, Simon, and anybody else. Speed okay, right? We won't be able to, of course, finish the entire company law today because it will get very monotonous, very monotonous. I don't mind, but then it it will be like an overloading for you all. Okay, so we'll do it till the time we can, and then the next session we'll do it tomorrow. It's a Sunday at 11:30 a.m. in the morning. Okay, and remaining part we'll finish there. Okay, now let's see. We'll do as much as possible. Everyone, guys, if you'll answer, no, if the things you'll know, and if you'll answer, you guys will get it in a more better way. Like, you'll understand it more easily. Okay. Okay. Now, allotment of securities. Securities can be allotted. Securities can be allotted only if the minimum amount stated in the prospectus is subscribed. We stated an amount. If that is subscribed, only then we can do the allotment. So minimum subscription should be there. Okay. And the amount payable on application must be at least 5% of the nominal value of the security or as prescribed by SEBI regulation. So see, if it's like 100 rupees, okay. So at the time of application, at least pay rupees 5, at least 5%. Why? So that we know that you're serious about buying the share. Okay, but what if that person doesn't get the share? Like for example, I could allot the share only to Aditya. I couldn't allot it to Shagun. But both of them had given the money. But my shares are fully subscribed. I'm oversubscribed. So I will have to return the 5 rupees to Shagun. Okay, within how many days, guys? Within 15 days. And if I don't do that within 15 days, interest 15% per annum. I will have to pay that. Yes, okay. Now, but I have given the share to Aditya, right? So when I have given the share, I will file a return of allotment. Within how many days? 30 days. Form, pass 3. With whom? ROC. That these are the details. Aditya, I have given the shares, his address, his occupation, and the number of securities I have allotted. All the details you will have to give it to ROC. What are the documents that will be attached? That Aditya has given me the money, consideration. Okay, if contract is not written, then complete particular stamped, then valuation report by registered value, that see my company does have this valuation and that's why Aditya has given me this kind of money. In case of bonus share, fine, you want to give bonus share, okay, but show me that your shareholders authorized you to do that. Okay, now payment of commission, guys. Company can pay commission to any person, okay, who is doing the work of subscription of securities. Okay, like for example, okay, first let me explain you underwriting. Now what is an underwriting, guys? Underwriting is minimum subscription. Okay, what was the rule? That minimum subscription of shares should be done. If minimum subscription is not done, so this underwriter guy, he purchases all the shares and he makes sure that the minimum subscription is done. Yes, okay. So then we have to give him a commission. So this commission has to be authorized by AOA. Commission must be out of the proceeds of the profit. Then the rate of commission must be 5% of the price at which the shares are issued. Okay. Commission, you can't give an unlimited commission, no? How many ever shares you're issuing? 5% should be the commission. Give that much extra. Okay, then prospectus shall disclose the name of the underwriters. Every issue has an underwriter, guys. Every issue. Because nowadays, of course, if the minimum subscription is not addressed, the entire issue will be cancelled. Right? So, no company wants that. That's why they underwrite it. Commission shall not be paid to any underwriter on securities which are not offered to public for subscription. So for example, you did not offer only these shares to public. So how you're saying it did not get subscribed? First offer it, let it get rejected, then it will come to the underwriter. Yes, okay. Now, what about the securities to be dealt with stock exchanges? So company making public offer shall, before making such offer, whenever you're making a public offer, make an application to the stock exchange that, listen, I want to list my securities with you. Okay, and also give them the prospectus. Application money, whatever application money that I'm getting. Okay, see, I got 5 rupees from Shagun, 5 rupees from Aditya, right? I have to deposit it in a scheduled bank. Okay, I will not use it for any other purpose. Any other purpose. This 10 rupees is still theirs. Right? Okay. So only against allotment, like when allotment is done, when I'm doing the allotment to them, only then this money can be utilized. Otherwise, no. Okay. Okay, okay. Penalty again, 5 lakhs up to 50 lakh, 1 year. Major penalty because it's public money, no? The next is private placement. What do you understand by private placement? Any offer or invitation to subscribe to securities. Okay. Now, what are the key provisions? If we talk about private placement, it can be made only to few people. See, the name itself suggests, guys, private placement. So, private means only to few people, not exceeding 50. So, maximum how many people, guys? 50. Identified person, they can apply that, okay, you know what, I'm identified, I'm in this, within this 50, the board has said that they can give me shares, so please give me shares, I'm interested in buying your shares. Okay, single offer at a time, no fresh offer can be made unless, see, the previous private placement is already pending and you're making a fresh private placement. Don't, first clear the previous one. Okay, allotment timeline, once you are done with the private placement process, securities, within how many days have you need to allot it? Within 60 days. Separate bank account needs to be maintained. No advertisement, nothing is required because you don't want the money from public. Only these 50 people are doing it. Okay, company must file return of allotment within how many days? 15 days. In which form? Pass 3 with ROC. Okay, that these are the details of all the allottees. Now, shareholder, does it require prior approval of shareholders? Yes, because you're giving these shares only to few specific people, no, only to 50, only to 50 people you're giving. So, of course, it requires special approval. Okay. Explanatory statement, that must also be there. Now, limits and documentation. See, in a year, you can give an offer to maximum 200 people. Private placement, okay. Pass 4, all the details will be there. And you have to file it electronically. Complete record is maintained in pass 5, and the return with ROC with all the details of to the people who have whom you have given private placement in pass 3 within 15 days. Yes, yes. Anybody any doubts, guys? Anybody any doubts? Yes or no? Anybody any doubts? Yes, all clear. Everyone, all clear. Anybody any doubts? No, ma'am, all clear. Aditya, you've been so consistent, yeah, Aditya. Wow. Appreciated. Very good, Simran. Very good. You've been consistent. Nice, guys. Nice. Good. Well done. Okay, let's talk about share capital. Okay, now if we talk about a share capital. So what is a share capital, guys? Kinds of share capital. First of all, we know equity share capital, correct? Equity share capital, they have voting rights, correct? And when it comes to dividend, do they get the dividend first? No, it's the preference share capital holders who get the dividend first. Now, who are the equity shares with differential rights? Generally, the rule is 1 share, 1 vote. But here it can be 1 share, 3 votes. This is a share with differential voting right. Can you issue this? Yes. Only if AOA says yes, you can. Ordinary resolution, postal ballot, and maximum 26% of your capital can be differential voting rights. Maximum 26. Okay. And if you have made no defaults in payments, filings, and consistent profit record, you've been earning profit for the last 3 years. If all these important pre-star market, if all these conditions are satisfied, then you can issue equity shares with differential voting rights. Got it? Gotcha? Yes. Explanatory statement. All the details must be contained in the ES, the total number, differential rights, reasons, allocations, voting rights, etc. etc. Conversion. Existing shares cannot be converted into differential voting rights. If you want, issue new shares, but you cannot convert the existing into differential voting. All the disclosures should be given in the board report about why have you issued this DVRs, to whom have you issued, at what price have you issued, what was the reason, what are the privileges that these people are getting, have you maintained the register of these people? Yes. Okay. Now, share certificate. Guys, once a board resolution is done, a share certificate is issued. What is a share certificate? A share certificate contains the amount of shares you hold, the name, okay, then the amount that you have paid, all the details. Okay, now guys, we don't have the share certificate funda because this was generally done for the old shares. Now it's like everything is online, everything is demat. You don't need a new share certificate or an old share certificate, okay, because everything is online. No. Now, delivery of certificate. It specifies delivery timeline: 2 months from incorporation allotment, 1 month from transfer transmission, 6 months for debentures. So, the moment you get incorporated, within how much time are you supposed to receive the share certificate? 2 months, 2 months, 2 months. Transfer transmission, 1 month, 1 month. If I transfer my share to you within 1 month, and debentures, 6 months. Yes, yes, everyone. Now, issue of sweat equity shares. Now, let's talk about sweat equity shares. What is sweat equity shares? So, see, there are employees in your office who are really doing great work. And you, as a token of respect, as a token of appreciation, you want to give them something. You want to gift them something. So, what do you give? What do you gift? Sweat equity. Okay, instead of giving them, like cash, you give them sweat equity. Also, like for example, they've invented something great in your company. Just 1 second, my phone rang. 1 second. Yes, so also like they've invented something great in your company, they've got a patent to your company or something like that. And even in such a case, you want to give them some returns. Then what do? Sweat equity. Clear? Yes. So a special resolution needs to be passed, number 1. Now, you need to specify the number, the price, to whom you're giving, which employee. Are you complying with SEBI? What is the limit? 15% of PUC of 5 CR per year. If you want to only give sweat equity, this is the maximum limit. And overall in the company, 50%, 25% overall. And for startups, it is 50%. Okay. It can be locked in for how long? 3 years. Hello. Yes. Now, let's talk about Yes, as we were talking about sweat equity, let's continue. So, special resolution has to be passed. You specify the number, the price, the shareholders to whom you've given this share, compliance with SEBI regulations. What is the limit? 15% of PUC or 5 CR per year, 25% overall. If, for example, if your capital is 100, out of which 25 rupees you can give it for sweat equity. Startups 50%. Lock in for 3 years. The employees cannot do anything for 3 years with these shares. Board maintains SH3 and all the details. Why are sweat equity shares given instead of normal shares? Okay, sweat equity shares are given instead of normal shares because you are giving this to, they are like specifically given to employees, no? They're specifically there for your employees and they are in return of the sweat that the employees have given for your company and they're given at a discount. And generally, normal shares you cannot issue at discount. So that's why sweat equity. Okay, got it? Gotcha? Yes. Now, bonus shares you give it for free. Bonus shares are entirely given for free. So if you're already a shareholder of the company, you'll get another shares for free. It should just be authorized by AOA, the board meeting, general meeting, no defaults on deposits, statutory dues. All the shares are fully paid up. Only after that you can give the bonus shares. Okay. Can you replace dividend with bonus? No. Then don't give dividend. Only give bonus. Only give dividend. But you can't say, okay, I had declared dividend, but now I don't want to give it to you. I'm giving you bonus. Don't do that. ESOP. Unlisted companies, they must obtain shareholder approval by special resolution. Okay. If we talk about ES, explanatory statement. So what are ESOP? Again, the name itself suggests these are given to employees. You just need to pass an SR. Because they are your employees, you need to give them preference, no, over the other general public. That's why. Now, ES will include what is an explanatory statement. It includes all the details too. Which employees you gave, what are the appraisals, what is the price at which you've given, what is the lock-in period, what are the standards that you've followed. And employees means doesn't mean promoters or shareholders. Huh? It will exclude it. Now, promoters, you can't say promoters are also employees and then you're giving them shares. No. Okay, this is maintained in SH6. Voting rights of equity shareholder, it's up to the paid up equity capital. Preference shareholder cannot vote. They can vote only in case if their dividend stays unpaid for 2 years. Only then they can vote. Okay. Variation of shareholder rights, special resolution 75%. Dissent, people who do not approve it, 10% of them, they come together, they can apply to the tribunal within 25 days. If you want to transfer your share, I want to transfer my share to you, I will have to file form SH7 within 60 days. Okay. If my shares are partly paid up, means I'm transferring a liability also. So SH5. Preferential offer. Preferential offer, you select few people and you give shares to them. Alteration of share capital. Can you alter share capital? Of course, you can increase it, you can reduce it. Whatever you do, just file form SH7 within 30 days. Okay, 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 okay. Done. Just 1 second, guys. Just 1 second. Is the screen visible? Yes. Okay. Now, reduction of share capital. If we talk about reduction of share capital, so you will have to pass a special resolution to reduce your share capital or to cancel the excess capital. Okay. Now, SPA, what is a securities premium account, guys? So, if it's a share at 10 rupees, the face value is 10 and you are issuing it at 12. So, 2 rupees is your SPA, securities premium account. Now, how can you charge this? Because of the goodwill of the company. If the goodwill is good, you can charge this SPA, okay? So, whether for cash or otherwise, you can issue shares at a premium. So, this 2 rupees will be transferred to the SPA account and this 10 rupees will be transferred to your share capital account. Clear? Now, SPA. Now this 2 rupee, when you're transferring it to a bank account, for what all can you use this 2 rupees? Either you issue fully paid up bonus shares, or else you can write off the preliminary expenses, the expenses during incorporation, you can write them off, the discount, the commissions, expenses while you are issuing debentures or shares. Then when you are redeeming the preference shares, then you have to pay the premium. Okay, so even for that you can write this off, you can use these 2 rupees and you can use it even for purchasing the company's own shares. Okay. Now, as I said, Aditya, you asked me this question. So as I said, that shares cannot be issued at a discount. Okay. Transfer and transmission of shares, we've already done this in details. Can we transfer shares to somebody else? Yes, absolutely. Transmission means one person is dead. Now this share automatically becomes of the legal representative. Yes, okay, okay. Now, punishment for personation of a shareholder. What is personation? If you are trying to show that you are someone else and you are misusing it, okay, you're trying to show that you're the shareholder, then this is what personation means. Okay, this is the punishment. Okay, now where a company refuses to register transfer, so the transferee must be notified within how many days, guys? 30 days. That reason must be given why I'm not registering your name. Okay. Ratification of register of members. So, you can make an appeal to the tribunal if the name is wrongly entered in the register. Then the tribunal, it will decide that they need to ratify the register, damages must be given or whatever. Preference share capital. Guys, preference share capital, they get preference, we already discussed a while back, they get preference in case of dividend. Second, in case of winding up, they will get the money first. Issue of preference share capital, SR. It should be there in the AOA. Then no default in redemption of earlier preference shareholders. Only then you can issue new preference shareholder. And when you pass a resolution, what all must the resolution specify? That they will be getting a priority in dividend. That they will be getting a priority while winding up. What is the dividend type that they will be getting? Cumulative or non-cumulative? Non-cumulative means after few, if for example, if for 2 years you do not get your dividend, okay, because it's compulsory to give dividend to preference shareholders. For after 2 years, you still do not get your dividend. In such a scenario, after these 2 years, you get a voting right. Also, on the third year, you will get the dividend of all 3 years. This is how the rule goes. So that you need to show that if it's cumulative or non-cumulative. Then when will it be converted to equity or it's non-convertible? Voting rights, redemption terms, explanatory statement will give all the details, the number of shares, the value, why are you issuing these shares, how will the dividend be there, what is the shareholding pattern, all the details. Okay. Okay, now issue and redemption of preference shares. Prohibits issuing irredeemable preference shares. Irredeemable means lifetime they cannot be redeemed. You cannot take the money back lifetime. So you cannot issue such shares. Redeemable within 20 years or maximum up to 30 years. That should be done. So 20 years max for normal companies, 30 years for infra companies. Okay. Oops. Oops. Just 1 second. Just 1 second. I have just come way ahead. Where were we, guys? Where were we? Yes. So, just 1 second. Where were we? We've done a lot today. We've covered so many concepts. Like majority of the part. Yes. So now, if we were talking about redemption of preference shares, okay? Period and condition for redemption. There is a fixed time that after this your shares will be redeemed, or it's at the company's option, or it is at the shareholders' option. Anyhow, it's okay. Redemption is done out of the profits or proceeds of a fresh issue. The shares must be fully paid up. The transfer is done to Capital Redemption Reserve Account, CRRA. Okay, and when you're redeeming and the premium is being payable, that must be payable from the premium, okay, that you already have, the SP account that we were talking about in the last page. Okay, now further issue of redeemable preference shares. A company who is unable to redeem shares or pay dividend, okay, they cannot issue further preference shares. Because why? They are unable to redeem shares or they are unable to pay a dividend. Okay, now, but this company, if the tribunal approves it and if the SR is there, the shares can be redeemed immediately, even if the shareholders are not consenting. Okay, so for example, company, they want to redeem the shares now. They want to pay back, but they're not able to do so. Okay, or they're not able to pay the dividend, maybe. So they can take an SR, they can go to the tribunal, and it doesn't matter if the other shareholders are not consenting, but they can redeem everybody's shares now. Okay, okay. Buyback. Buyback means buying the company's own shares. Now, obviously, buyback, first it must be there in the AOA. It can be approved by an SR. When buyback is 10% or less, then a board resolution is also okay. Board resolution, 10%. Maximum buyback, 20% of PUC plus FR. Okay. Okay. Then the ratio of secured debt to capital and free reserves cannot be more than 2:1. Even post buyback, it has to be 2:1. Then when the shares that you're buying back should be fully paid up. Okay. And listed companies, you will have to follow the BOSH regulations, SEBI regulation. Now, within 2 buybacks, there should be a gap of at least 1 year. SR will be passed disclosing all the details, why you're buying back, what you're buying back, what is the amount that you're giving to the shareholders. Explanatory statement must be there. All the details included in the explanatory statement. On what board meeting did you exactly approve this buyback? Why are you doing it? What shares are you buying back? At what price are you doing it? What is the maximum amount? From where have you got the fund? Till when will you complete it? Okay. What is the shareholding of the promoters? Have you done no default in payment of deposits and everything? Are you solvent? And you're sure no, in 1 year you won't become insolvent. Okay. Done. Okay. Now, letter of offer, LOO. You call this LOO in professional terms. Seriously, genuinely. Now, what is LOO? LOO. What is LOO? Letter of offer. Letter of offer, guys, contains all the details regarding the buyback process, like what all is going to be included in it. Okay. So, company, first it needs to be authorized by SR. Okay. It will file an LOO in SH8 with ROC. It will be signed by at least 2 directors, and the offer must be dispatched to the shareholders within 20 days. Within 20 days. Now the offer period, guys, it remains open for how many days? 15 to 30 days. Okay. It can even remain open for less than 15 days if all the shareholders said, no, we are going to do this in the first 3-4 days only. So fine, why you want to keep it open for 15 to 30 days? Okay, okay. Payment and bank account, separate bank account, create a separate bank account. And as we know, if you want to return the money, do it within 7 days. First the buyback closes, okay, then the 21 days time period is there, and then your 7 days to return the money back. Sources and solvency, you have to declare that you are solvent and you are going to be solvent for at least another 1 year. If the shares are physically destructed, people used to, before, in before days when there was a buyback, people used to put fire on it. Yeah. Register and return, maintain it in form SH7 and file a return in SH11, even with SEBI. Obligations of the company, you are supposed to give all factual information, no fake information. Okay, prohibition of buyback. Guys, you cannot buy back through subsidiaries. Like if you are a company ABC, your subsidiary is XYZ. You're doing a buyback. Now XYZ, okay, now you cannot do that because XYZ is your subsidiary, or you can also call it an investment company. Okay. So here you cannot do a buyback through your XYZ company. Okay, or else when a default is pending already, even in such a scenario, you cannot do a buyback. And the last part of the day, guys, if this part is done, we'll stop. Okay, we'll just finish debentures and then we'll stop. Now, what do you mean by debentures? Debentures, stock, bonds, any instrument, okay, it's like a credit and it has a charge on the assets. Okay, mortgage. In Hindi, we call it girvi. Now, issue of convertible and non-voting debentures. So, a company can issue debentures which can later be converted into shares. So, if you're a person who's confused that should I give loan to the company or should I become the owner? So, you can buy convertible debentures. For few days, become the creditor. After few days, become the owner. Okay. Secured debentures means if the company does not pay the money, there is an asset that is kept for you and that asset will be relinquished and you will be given the money back. Okay. So, generally, debentures should be redeemed within 10 years. For infrastructure, it can be taken up to 30 years. Debentures, there is a security always on the assets. Then who takes care of that asset? Debenture trustee. Okay. Then with him, you execute a debenture trust deed. Yes, now asset is in favor of the trustee, but the trustee is working for the benefit of the debenture holders. Now, who's a trustee? There is a written consent that must be taken from him. Okay. Now, certain people cannot be appointed as trustees like promoters, directors, KMP, employees, or people who have financial relationship with the company. Obviously, because they'll be partial towards the company. If tomorrow the company defaults in paying, they won't do any action against the company, right? What is the duty of debenture trustee? Make sure that all the defaults, like the company, first of all, you need to make sure that all the debenture holders are protected, the property, the security is safe, and this security is enough to discharge the debts of all the debenture holders. The letter, the debenture trust deed, everything is consistent as per law. There are no breaches. Okay. And the debenture trustee can also appoint a director on behalf, like who will protect the interests of all the debenture holders in the boardroom, right? Debenture redemption reserve, DRR, mandates a DRR from profits available for dividend. It specifies DRR applies only to the non-convertible portion. Remember, debenture redemption reserve, it applies only to the non-convertible portion because the convertible portion later on is going to get converted into equity, right? DRR funds can be used for redemption. Now, when you want to pay back the creditors, this fund, DRR, you create this fund to pay back the creditors always, okay? And minimum 15% of debentures maturing during the year must be invested by 30th April in deposit with banks, okay? So, whatever amount of your debentures that you are going to redeem, whatever, but you know that the end of the year this is going to be maturing, I have to pay, so you have to deposit at least minimum 15% of it. Okay, last part as I'm saying, trust deed in SH12 must be executed within 3 months. Okay, debenture trustee, he should exercise his due diligence because all the debenture holders are trusting him. They are completely trusting the debenture trustee. Okay, done. That's it. Okay, so the further part from deposits, we will be doing this tomorrow. Okay, tomorrow at 11:30 a.m. we will be finishing company law. We will be finishing the entire company law. Yes, guys, any doubts? Everybody clear? Any doubts? Yes. Thank you, Aditya. Thank you. Okay. Okay, Simran, very good, guys. Both of you all, very good. You all have been great and so consistent in a theory subject. That too at this time, very good. Appreciated, both of you all. Appreciated from the heart. Okay. I will see you guys tomorrow. Thank you, Simon. Okay, so I will see you guys tomorrow at 11:30 a.m. and we'll finish the entire Companies Act and we will increase the speed more. Okay, chalo. Thank you so much, guys. Take care of yourself. See you very soon. Thank you so much. Bye bye.